Helen Kowalski taught 4th grade in Clark County, Nevada for 31 years. She taught fractions. She taught the water cycle. She taught children how to write a 5-paragraph essay. And after 3 decades of showing up before dawn, grading papers until midnight, and taking home a salary that never once broke 6 figures, Helen did the one thing every American is told will set them free. She paid off her house. In August of 2024, Helen wrote the final check, $412. She framed the satisfaction of the mortgage letter. Her daughter took a photograph of her standing on the front porch holding that letter above her head like a championship trophy. The house was worth $498,000. Helen owed $0. That photograph was the last image of Helen Kowalski as a homeowner. 7 months later, Helen had a mild stroke, not catastrophic, not the kind that takes your speech or your memory permanently, but enough to land her in a rehabilitation facility for 9 weeks. 9 weeks of physical therapy, 9 weeks of relearning how to button a blouse with her left hand, 9 weeks during which she was not standing at her mailbox on the corner of Desert Bloom Drive. And in those 9 weeks, a single piece of mail arrived at that empty house. A property tax bill, $1,187. Not $14,000, not $140,000. $1,187, less than what she spent on groceries in a good quarter. That bill sat in a mailbox that nobody opened, in a house that nobody was watching, attached to a deed that had exactly one name on it, hers. Here's what happened next. And if you own your home free and clear, I need you to stop whatever you're doing and listen to me like your house depends on it, because it does. Clark County recorded a tax lien against Helen's property. That lien was auctioned at the county's annual tax lien certificate sale. An investor, a limited liability company registered out of a P.O. box in Scottsdale, Arizona, purchased that lien for the amount of Helen's delinquent taxes plus fees. Total cost to the investor, roughly $2,000. That investor now held a legal claim against a $498,000 home. The statutory clock started ticking. Helen did not know the clock had started. Helen was in a rehabilitation facility trying to relearn how to hold a fork. Nobody told her. Nobody called her daughter. Nobody checked to see if the owner of this paid-off home was alive, dead, competent, or lying in a hospital bed 30 miles away. The system does not care. The system is not designed to care. The system is designed to convert your equity into somebody else's payday. And it does so with the mechanical indifference of a paper shredder. Now, the United States Supreme Court in Tyler versus Hennepin County in 2023 ruled unanimously, 9-0, that governments cannot simply keep the surplus equity after a tax foreclosure sale. Chief Justice John Roberts wrote, and I will paraphrase because this matters, the taxpayer must render unto Caesar what is Caesar's, but no more. That ruling was supposed to end home equity theft in America. Every legal commentator, every newspaper editorial board, every talking head on cable news declared victory. They told you the problem was solved. They lied, or more charitably, they did not read the fine print. And in the business of stripping wealth from the elderly, the fine print is where they bury you. Tyler versus Hennepin County said the government cannot keep the surplus. What it did not say, what the court very carefully left open, is how much of your equity gets consumed by fees, penalties, interest, legal costs, title search fees, publication costs, and administrative surcharges before that so-called surplus is even calculated. And this is where the modern equity theft machine operates. It does not steal your equity in one clean swipe anymore. It bleeds it out through 1,000 procedural cuts. You lose the house, you get evicted, you spend 18 months fighting to recover whatever surplus is left after the county and the investor have layered on every permissible charge. And by the time you get a check, if you ever get a check, you have lost your home, your stability, your dignity, and a significant portion of the equity you spent 30 years building. If that makes you furious, good. That fury is the correct response. Here is the sarcastic disclaimer the suits make me read. This is not financial advice. This is a survival briefing for an unguarded vault. If you still trust the same system that lets a $2,000 lien consume a $500,000 home, by all means, go consult the professionals who forgot to mention any of this to you. For the rest of you, stay with me. Let me walk you through the actual mechanics of what I call the dead equity foreclosure trap. Because once you understand how the machine works, you will understand exactly where to jam the wrench. The trap begins the day you celebrate, the day you burn the mortgage, the day you frame the payoff letter, the day you think you are finally, completely, untouchably free. And I want you to hear me when I say this. That day is the single most financially dangerous day of your life as a homeowner. Not because paying off your mortgage is bad, paying off your mortgage is wonderful, but because for 30 years, you had a silent guardian angel that you never thought about, never appreciated, and never realized was protecting you, your escrow account. For 3 decades, your mortgage servicer collected a portion of your monthly payment and set it aside in escrow. Every year, that servicer paid your property taxes on your behalf. You never saw the bill. You never opened the envelope. You never had to remember a due date. The bank handled it because the bank had skin in the game. They held the mortgage. If your taxes went unpaid and a tax lien attached, that lien would jump ahead of the bank's mortgage in priority. The bank was not protecting you out of kindness. The bank was protecting its own collateral. But the effect was the same. Your taxes got paid every year without fail. The moment you pay off that mortgage, the escrow account closes, the bank walks away. And for the first time in 30 years, a property tax bill shows up in your mailbox, addressed to you with your name on it. And nobody else on earth is responsible for making sure it gets paid. Now, if you're 62 years old and sharp as a tack, and you check your mail every single day, this is not a crisis. You open the bill, you write the check, you move on with your life. But if you are 78 and you just had a stroke, if you are 81 and your early stage dementia means you sometimes put the electric bill in the recycling and the junk mail in the filing cabinet, if you're 75 and you went to visit your grandchildren in another state for 3 months, if you are any age at all and you simply, humanly, made the mistake of missing a single piece of mail, the dominoes start falling and they fall fast. Let me show you exactly how fast they fall in 3 different states, because this is not a theoretical exercise. This is happening right now in 2026 in every county in America that runs a tax lien or tax deed sale. And the rules are different in every state, which means the trap is calibrated differently depending on where you live. In Florida, the Sunshine State, the retirement capital of the Western Hemisphere, more retirees with paid-off homes per capita than almost anywhere in America. Florida is a tax lien certificate state under Florida statute, section 197(2). Hear how it works. Your property taxes become delinquent on April 1st of the year following the assessment year. A 3% penalty is immediately added. Interest accrues at up to 18% per year. The county tax collector then sells your delinquent tax bill at an annual certificate sale. The winning bidder is the investor who accepts the lowest interest rate on the certificate. That investor pays your tax bill and now holds a legal lien against your property. You have 2 years from April 1st of the certificate issuance year to redeem that certificate by paying the full amount plus the winning interest rate plus fees. If you fail to redeem within 2 years, the certificate holder can apply for a tax deed sale. The county clerk then auctions your home. And here's the part that the Tyler ruling was supposed to fix, but the machinery still punishes you for, even with the surplus return requirement, you have now lost your home, you are evicted, the property is sold to a stranger at auction. You are then supposed to receive whatever surplus remains after the delinquent taxes, interest, all accumulated penalties, the certificate holder's costs, title search fees, recording fees, publication costs, clerk processing fees, and attorney's fees are subtracted. Take a $500,000 home. Start with a $1,500 or delinquent tax bill. Add 18% interest for 2 years. That is $540 in interest alone. Add the 3% penalty. Add the certificate sale administrative fee. Add the tax deed application fee. Add the cost of title search. Add the cost of mailing certified notices to every party of interest. Add the cost of publishing notice in local newspaper for 4 consecutive weeks. Add the clerk's processing fee. Add the investor's attorney's fees for filing the tax deed application. By the time your home sells at auction, that original $1,500 bill has metastasized into $8,000, $12,000, sometimes $15,000 in charges. And that is before the auction itself, which may sell your home for below market value because foreclosure auctions rarely achieve fair market value. And notice something critical. The question of what constitutes fair market value at a tax deed auction is still being litigated in federal courts in 2026. Your home can sell at auction for substantially less than its appraised value, and the surplus you receive is calculated based on the sale price, not the appraised value. So, your $500,000 home sells at auction for $380,000. After all fees and costs, you might eventually receive $360,000. You lost your home. You lost over $100,000 in equity, and it all started with a $1,000 or $500 bill you could have paid in your sleep. Now, let us talk about Ohio. Ohio is a hybrid state. Counties can sell tax lien certificates to investors, or they can foreclose directly and sell properties at an auditor's sale. Under Ohio Revised Code Section 5721.38, after a tax lien certificate is sold, the property owner has 1 year to redeem. Just 1 year. 12 months. Interest accrues at 18%. If the owner does not redeem within that 12-month window, the certificate holder can file a foreclosure complaint in court. And in Ohio, if the county itself forecloses and sells the property at an auditor's sale, which is a direct tax deed sale, there is no redemption period at all after the sale. Once the auditor's deed is issued, it is final. The property is gone. The title transfers free and clear of prior encumbrances. 1 year. That is the entire margin of safety between a paid-off home and homelessness for a senior in Columbus, Ohio. 1 hospitalization. 1 family emergency. 1 bout of confusion. One lost piece of mail. 12 months, and you're standing on the sidewalk watching a stranger change the locks on the home where you raised your children. Now, let us talk about California. California is a tax deed state. The county does not sell liens to investors. The county sells your home directly at public auction. Under California Revenue and Taxation Code Section 3691, if your property taxes remain unpaid, the property becomes tax defaulted. After 5 years of default, the county tax collector can sell the property at auction. 5 years sounds generous until you realize two things. First, there's no redemption period after the sale. Your right to redeem expires at the close of business on the last business day before the auction date, per Section 3706. Once that gavel falls, the buyer receives a tax deed free and clear. Second, per Section 3712, the deed conveys title free of all encumbrances existing before the sale. Home equity lines, reverse mortgages, everything is wiped out. In the state of California, there is no extended right of redemption. Your home is gone permanently. So let me state the debt equity foreclosure trap in plain language, because I want there to be zero ambiguity about what is at stake. If your home is fully paid off and your name is the only name on that deed, a single hospitalization can cost you the equity you spent 30 years building. Not because the medical bills are high, not because the insurance did not cover it. Because while you were in the hospital, a $400 property tax bill arrived at a house where nobody was home. That is the trap. That is the crime scene. That is the systemic failure that nobody in mainstream financial media is talking about, because the people who profit from the system also happen to be the people who buy advertising on those networks. Now, I want to tell you about the woman who will never lose her home. Not because she is smarter than Helen Kowalski, not because she has more money, but because she did one thing, one single thing, that Helen did not do. Her name is Margaret Chen. She is 76 years old. She lives in a 3-bedroom ranch in Clearwater, Florida. The home is worth $485,000, paid off entirely since 2021. Margaret set up a revocable living trust, not because she was worried about probate, although that is a benefit, not because she was worried about estate taxes, although with the estate tax exemption at $15 million per person under the One Big Beautiful Bill Act, she is nowhere near that threshold. Margaret set up the trust and named her son David as successor co-trustee because her estate planning attorney told her something that every single retiree with a paid-off home needs to hear. And I will say it again because this is the part they hide. When your home is held in a revocable living trust with a named co-trustee, that co-trustee has the legal authority and the fiduciary duty to monitor the property, pay the bills, and intervene the moment anything goes sideways. David Chen receives duplicate tax notices. David Chen has online access to the trust's dedicated checking account. David Chen gets automated alerts from the county property appraiser's office. When Margaret had a fall in January and spent weeks in an assisted living rehabilitation facility, David logged into the county tax portal, confirmed the property tax bill was due in March, and paid it from the trust account. Total time, 11 minutes. Total cost, the amount of the tax bill. The home remained untouched, unlined, and completely secure. Margaret came home from rehab, walked back into her house, and never knew how close the alternative reality was. Because in the alternative reality, the one where the home was held in Margaret's name alone with no co-trustee, no backup, no second set of eyes, that March tax bill would have gone unpaid. By April, the county would have recorded a delinquency. By June, the certificate sale. By 2027, a tax deed application. By 2028, an auction. Margaret would have come home from rehab to find a foreclosure notice taped to her front door. And before somebody in the comments says, well, just add your kid to the deed, stop. Do not do that. That is a different trap entirely. We are talking about a potential tax bill of $60,000, $80,000, over $100,000 because you inadvertently made a gift of a partial interest in the property and destroyed the step-up in basis that your heirs would have received under Internal Revenue Code, Section 1014, upon your death. Do not add anyone to the deed. That is the amateur move that cost families 6 figures. The professional move is the trust. The trust is the shield. Let me walk through the math one more time because I want this burned into your memory. Scenario A, Helen Kowalski. Home value $500,000. No mortgage, no trust, no co-trustee. Home titled in her name alone. Helen has a stroke and misses a $1,500 property tax payment. The county records a lien. An investor buys the lien for approximately $2,000. The statutory redemption period expires. The investor applies for foreclosure. The home is sold at auction. After all fees, penalties, interest at 18%, attorney's costs, title search fees, publication costs, and the auction discount below fair market value, Helen's net recovery of surplus is somewhere between $350,000 and $400,000. She started with $500,000. she lost her home. She lost between $100,000 and $150,000 in equity to fees, penalties, below market auction pricing, and systemic extraction. All because a $1,400 bill went unopened for 9 weeks. Scenario B, Margaret Chen. Home value $485,000, no mortgage. Home held in a revocable living trust. Son David is named successor co-trustee. Margaret falls, goes to rehab for 6 weeks. David, as co-trustee, receives the delinquent tax notice, logs into the county portal, and pays the bill from the trust checking account. Cost to Margaret: the amount of the property tax. The home is 100% secure. No lien, no auction, no investor, no foreclosure, no loss of equity, no loss of home, no loss of dignity. The total cost of setting up that revocable living trust was between $1,500 and $2,500, depending on the attorney and the state. Margaret paid $2,500 once to protect $485,000 of equity forever. Helen paid nothing to protect her equity and lost over $100,000. Now, let me address the elephant in the room. Some of you are thinking, my state has a homestead exemption, and that protects me. Your homestead exemption does not protect you from property tax liens. Not in Florida, not in Ohio, not in California, not anywhere. The homestead exemption protects your home from general creditor judgments. If someone sues you and wins, the homestead exemption prevents that creditor from forcing the sale of your primary residence. But it has absolutely nothing to do with property tax liens. Property tax liens are senior to everything: senior to mortgages, senior to homestead protections, senior to judgment liens. A property tax lien is the single most powerful legal claim that can be placed against your home, and the homestead exemption offers zero defense against it. If someone told you otherwise, they were wrong. And while I am dismantling myths, let me address the auto pay fallacy. Some of you are thinking, I signed up for auto pay with the county, so I am fine. Auto pay systems fail. Bank accounts get frozen. Debit cards expire. Checking accounts get closed and reopened with new routing numbers after a fraud event. If your autopay fails and you're not monitoring it, the result is identical to never having set it up. A missed payment, a lien, a foreclosure. Autopay is a convenience feature, not a legal failsafe. A co-trustee has a fiduciary obligation to act. Your bank's autopay system has a terms of service agreement that explicitly disclaims liability for failed transactions. Now, let me give you the action checklist. The steps you need to take this week. Not this month, not this quarter. This week. Step 1. Confirm the current title status of your home. Go to your county recorder's office or look it up online. Is the home in your name alone? Is it in joint tenancy with your spouse? Is it already in a trust? You need to know the answer to this question before you do anything else. Step 2. If the home is in your name alone or in joint tenancy with only your spouse, contact an estate planning attorney in your state and establish a revocable living trust. Retitle the home into the trust. Name a trusted adult child, a sibling, a professional fiduciary, or a licensed trust company as your successor co-trustee. This is the single most important legal document you will ever sign, and it is not the document itself that saves you. It is the co-trustee provision that saves you. The co-trustee is the second set of eyes, the backup, the person who steps in when you cannot. Step 3. Open a dedicated checking account in the trust. Fund it with enough money to cover at least 2 years of property taxes, homeowners insurance premiums, and any HOA dues. Give the co-trustee signatory authority on this account. This is the war chest. This is the account that your co-trustee uses to pay the bills when you are in the hospital, when you are traveling, when you forget. Step 4. Set up automated redundant alerts for your property tax payments. Register with your county property appraiser's website and set up email and text notifications for your parcel number. Have those notifications sent to both you and your co-trustee. Some counties, including several in Florida and California, now allow you to register multiple email addresses for tax notifications on a single parcel. Use that feature. If your county does not offer it, set a calendar reminder for 30 days before the tax due date and share that calendar event with your co-trustee. Step 5. Request a duplicate tax bill. Most counties will mail a duplicate tax bill to a second address upon request. Have the duplicate sent to your co-trustee's home address. This costs nothing in most jurisdictions. And it means that even if your mail is lost, stolen, or unread, a second copy of that bill is sitting on your co-trustee's kitchen counter. Step 6. File a homestead declaration if your state allows one. This does not protect against tax liens, but it protects against other creditor judgments and costs nothing to file. Step 7. Review your property tax status annually. Once a year, log into your county tax portal and confirm all taxes are current and no liens exist. Have your co-trustee do the same review independently. 2 sets of eyes. Redundancy is not paranoia. Redundancy is the difference between keeping your home and losing it. That is 7 steps. You can complete all 7 in less than 30 days. The total cost is the attorney's fee for the trust, typically from $500 to $2,500, plus the cost of a checking account, which is usually free. For an investment of less than $3,000, you are protecting $250,000, $500,000. In some markets, $1 million or more of home equity from a trap that starts with a piece of mail you did not open. And here's the questions that should keep you awake tonight. If you went into the hospital tomorrow, who is checking your mail? Who is monitoring your property tax account? Who has the legal authority to step in and pay that bill? If the answer is nobody, you are Helen Kowalski. You're sitting on a paid-off home with a bullseye on it, and the only thing standing between you and a foreclosure auction is whether or not you get sick at the wrong time of year. That is not security. That is a lottery ticket with your home as the stakes. The county tax lien redemption clock does not care if you are in the hospital. Once the statutory period expires, the foreclosure is ruthless and final. And I need to tell you something else. The information I just gave you is not secret, it is not classified, it is sitting in plain sight in every state statute book in America. Your county treasurer knows it, your property tax collector knows it. The investors who buy tax lien certificates know it very well. The only people who do not know it are the retirees whose homes are at risk. And the reason they do not know it is because nobody has any financial incentive to tell them the county needs the tax revenue. The investors need the liens. The attorneys need the foreclosure fees. Every single player in this system profits from your ignorance, and not one of them is required by law to send you a warning that says you just paid off your mortgage and you're now more vulnerable than you have been in 30 years. That is why this information matters. The trust is not exciting. It does not make for dinner party conversation. But it is the single most powerful financial protection available to a retiree with a paid-off home. And before you try to solve this problem yourself by simply adding your child's name to the deed, stop, freeze, do not touch that deed. We are talking about the complete destruction of the step-up in basis under Internal Revenue Code Section 1014, an inadvertent gift tax event, and a capital gains tax bill that will make your property tax bill look like loose change. Here's the final piece of math. Helen's failure to establish a legal backup cost her over $100,000 in stripped equity. The trust that would have prevented it cost $2,500. That is a return on investment of 4,000%. You will not find a financial product on earth that delivers that kind of return. What exists is the simple, boring, unsexy legal act of retitling your home into a trust and naming a co-trustee. It is not exciting. It does not make for dinner party conversation, but it is the single most powerful financial protection available to a retiree with a paid-off home. Retitle your home into a living trust. Assign a co-trustee immediately. Set up automated redundant alerts for your property taxes. Do it this week, because the county's lien clock is already running and it does not stop for anyone. Protect the house. Protect the legacy. Protect yourself.